Florida's fight for the finale, the case of Kayle Barrington Bates. For 43 years, one case has haunted Bay County, Florida, a brutal murder, a relentless legal battle, and now, a final execution date. This is the story of Kayle Barrington Bates, convicted of the kidnapping and murder of 24-year-old Janet Renee White in 1982. But even with overwhelming evidence, justice has been delayed for more than 4 decades. With the clock ticking down to 6 p.m. on August 19th, Florida prepares to carry out its 10th execution of the year. He will be put to death by lethal injection. Please like and subscribe if you're new to the channel. Kayle Barrington Bates. Background. Born on February 19, 1958, Bates, 67, is on death row awaiting execution. Bates's wife, Renita Bates, and the two have a son. At the time of the crime, they attempted to contact Renita Bates, but she would not return their phone calls. Mrs. Bates avoided all service of a subpoena in Bates's case. She remained distant, along with her son. Mrs. Bates said that after Kayle served in the National Guard in Miami and Panama, his behavior changed. When he returned from Miami, he withdrew. He was much more nervous and distant. Kayle did not want to go to Miami and did not want to leave his family. She mentioned that she frequently had nightmares. She described Mr. Bates's nightmares after his return from the Miami riots and that he was out of his mind. Kayle woke her up more than once with his nightmares. He would wake up screaming very loudly. She said he was acting crazy and didn't recognize where he was. Kayle snapped. Renita Sweat said Kayle wasn't very detailed about his service in Miami, but she knew he didn't want to go there in the first place. Jackie Bates, Kayle Bates's father, testified about Mr. Bates's behavior at the time of his arrest in 1982 when he was driving to Panama City from Tallahassee. When he saw him for the first time since the day of the arrest, Kayle was going crazy. He was babbling and talking so fast he sounded like a machine gun. Jackie could barely understand him, and she thought there was something physically or mentally wrong with Kayle because she was out of it, shaking and trembling. Kayle's reaction didn't seem typical of fear or emotion over serious accusations. She had never seen Kayle so extreme before. Kayle seemed overwhelmed, and the situation was really bad. Mr. Joseph Johnson testified that he served with Kayle Bates in the National Guard from 1977 to 1978 until Kayle's arrest. He described his training. He went through jungle training in Panama with Kayle, where they were trained in situations similar to those of the Vietnam War. The jungle terrain was very unforgiving and not a place where you wanted to make a mistake. He was also with Mr. Bates during the Miami riots of 1980. Subsequent medical reports on Bates's organ system indicate that he suffers from organ damage and brain damage. These damages and these deficits made him prone to overreacting in stressful situations, or in other words, losing control in stressful situations. In some tests, the results describe him as he has deficiencies in problem solving, particularly related to critical thinking based on language and comprehension. Conditional relationships. He had difficulties with memory and information retrieval, as well as with the retrieval of that information. He also had specific problems with auditory selective attention. That is, when there were distractions in the environment, he had difficulty concentrating and hearing the important aspects of something. Bates had a lower stress threshold at the time of the crime, according to a medical evaluation. He had difficulty processing information, like a malfunctioning computer. The kidnapping and murder of Janet Renee White. In June 1982 marked a turning point, a descent into irreversible darkness. It was a warm summer day, June 14, 1982, when 24-year-old Janet Renee White returned to work after lunch at a State Farm insurance office in Lynn Haven, Florida. She had no idea a predator was waiting for her. Kayle Barrington Bates, a 24-year-old delivery man from Tallahassee, had broken into the office while Janet was out. He'd made deliveries there before. He knew the layout. When Bates surprised White, She let out a bone-chilling scream and fought for her life. But no one heard her. He overpowered her and forcibly took her from the office building to the nearby woods. What happened next was savagery, where he savagely beat, strangled, and attempted to rape her, leaving approximately 30 contusions, abrasions, and lacerations on various parts of her face and body. And stabbed to death, she was left with over 30 wounds, her diamond ring ripped from her finger. Janet Renee White was a friend, a companion, a wife, a daughter, a member of her community, a responsible young woman, and much loved by all. The arrest. Kayle Bates didn't get very far. It was established that the victim was heard at 1:05 p.m., and Mr. Bates was arrested at 1:20 p.m. The crime lasted only a few minutes. He was caught at the crime scene, with Janet's blood on his clothes and her ring in his pocket. There was no doubt. He was guilty. Bates gave a statement at the time of his arrest. His claim that he did not kill Ms. White could establish that someone else committed the murder. Of course, each of these words mentioned in Mr. Bates's statements would vanish in the face of evidence presented, such as evidence collected from the victim's body, the rape kit, the victim's clothing, the blue cord, and Mr. Bates's clothing that could establish his presence at the crime scene. Trial and sentencing. Mr. Bates, an indigent defendant, was represented by his state-appointed attorney on July 6, 1982, facing charges of first-degree murder, kidnapping, sexual assault, and armed robbery. On January 20, 1983, the jury returned a verdict, finding Mr. Bates guilty of first-degree murder, kidnapping, attempted sexual assault, and armed robbery. On January 21, 1983, the jury voted in favor of the death penalty. On March 11, 1983, the court followed the jury's recommendation and sentenced Mr. Bates to death. On September 7, 1989, Mr. Bates's death warrant was signed. A new sentencing hearing was ordered years later, and in 1995, he was again sentenced to death. Of the 116 people summoned for jury service, only 6 were African American. Prosecutors excused some of those jurors without giving Mr. Bates the opportunity to respond. When lead counsel arrived the next day, he objected to the jurors being excused. His objection was overruled, and the new sentencing began. The defense argued against the death penalty. Evidence of organic brain damage with brain deficits on Mr. Bates's part was presented, but Doctors James Larson and Elizabeth McMahon could not testify that Mr. Bates thrived in stressful situations and that under stress his emotional controls broke down. They said he reacted impulsively without considering alternatives or consequences. No physician had performed the tests with the expertise. They were not certified psychologists, nor licensed in Florida, and they limited their practice to clinical and forensic psychology and adult neuropsychology. They did not meet the requirements to testify about Mr. Bates's condition. The state has not refuted that organic brain damage is a significant mitigating factor for mental health. This does not excuse trial counsel's decision not to present evidence of organic brain damage. The trial court denied all of these motions. After all the evidence was heard and presented to the jury, Mr. Bates, his worst fears were realized. After 3 hours of deliberation, the jurors sent a question to the judge if they could recommend life without the possibility of parole. When they were told no, the jury returned a verdict of death. The Bay County, Florida court handed down the conviction and death sentences at issue in this case. The legal system had spoken, but Bates wasn't done fighting. In 2006, during the post-conviction process, Mr. Bates filed a motion for DNA testing under the new Florida R-Crim Point 3.853 to definitively identify the perpetrator. The trial court denied the motion based on incorrect facts. DNA testing was denied based on Mr. Bates's inconsistent statements. Death rebellion and appeals. Bates, 67, with all appeals nearly exhausted, the final decision rests with the courts. If nothing changes, Bates will be executed by lethal injection on August 19th at Florida State Prison. He became another number in death row. Now he is waiting for the executioner to call him. Bates was sentenced to death before the trial began. Defense counsel failed to adequately argue the applicability of the alternative of life without parole and failed to oppose prejudicial arguments presented by the state regarding Mr. Bates's future dangerousness. Mr. Bates was denied effective counsel at the resentencing when trial counsel failed to present evidence of organic brain damage through an expert witness who was present in court and willing and available to testify. The state argued in its response brief on direct appeal that Mr. Bates fabricated 10 or more stories about what happened to the victim. The trial court acknowledged in its order that Mr. Bates denied giving a second recorded confession. Mr. Bates has repeatedly argued since his original trial that his statements were internally inconsistent and coerced. The trial court also denied DNA testing because it opined that there was no rape of the victim, only an attempted sexual assault. Of death and execution date. The Florida Attorney General's office argues that the state Supreme Court should reject efforts to halt Kayle Bates's execution, saying she forfeited her right to life by committing the crime. Arguing that convicted murderer Kayle Bates has exhaustively litigated and relitigated her trial and death sentence for the past 43 years, the state attorney general's office said the Florida Supreme Court should reject efforts to halt Bates's execution scheduled for August 19th. Bates forfeited his right to life by brutally stabbing a young woman after kidnapping, robbing her, and attempting to sexually assault her, the state argued. The simple truth is that Bates has been living on borrowed time for decades while his victims waited for the justice to which they are now entitled under our Constitution. Bates's time is up. Last year, the Florida Supreme Court rejected an appeal in which Bates sought to interview a juror from his 1983 trial. The appeal concerned a possible familial relationship between the juror and White, but Judge John Coriel wrote that Bates's attempt to interview one of his jurors is 40 years overdue. After the Florida Supreme Court ruling, Bates appealed to the U.S. Supreme Court, leading to the June 30th decision denying his request. Governor Ron DeSantis signed Bates's death warrant on July 18th, making him the 10th inmate executed this year in Florida. This ruling triggered attempts by Bates's lawyers in state and federal courts to block the execution. Bates's lawyers also argued that he was mentally ill at the time of the murder and that his organic brain damage was not considered. This was not a failed objection or a failure to ask, the brief stated. It was a complete disregard for a compelling form of mitigation that has long been used to declare capital punishment inappropriate. Aftermath. Pattern of racial discrimination. The death penalty in the United States and in Florida has been discriminatory. It has been imposed against those accused of killing Caucasians. The likelihood of execution is overwhelmingly higher in cases where, as in this case, the victim is white. Mr. Bates's death penalty was imposed under this pattern of racial discrimination. University of Florida Sociology. Professor Michael Radelet conducted a study of homicides in Florida between 1976 and 1987. As a result, Radelet determined, overall, white suspects are more likely to be sentenced to death than black suspects, 4.8% and 2.5% respectively. However, closer inspection reveals that this may be because 95% of white suspects are implicated in the murder of other whites. 86% of black suspects are convicted of killing other blacks, and those suspected of killing blacks are rarely sentenced to death. Radelet determined that cases with white victims are nearly 6 times more likely to receive the death penalty than those with black victims. These initial figures are not definitive of racial discrimination because several additional factors can contribute to the likelihood of a death sentence. Therefore, Radelet accounted for numerous qualitative differences in homicide cases, including accompanying felonies, the relationship between defendant and victim, the number of victims, the use of a gun versus another weapon, and urban versus rural location of the homicide. Even controlling for each of these variables, Radelet reported this central finding: controlling for all other factors, the odds of a death sentence are 3.42 times higher for defendants suspected of killing whites than for defendants suspected of killing blacks.